Hello, I am the Crimson Fox on Twitter, and some people have been asking me to explain how to opt out of an arbitration clause, and I'm also going to explain after that, I'm going to explain what exactly arbitration is and why it's not in your best interest as a consumer. So first, I'm going to explain first I should, disclaimer, I'm not a lawyer, I'm not a law student, I am a marketing student, but once I go to actually work, I'm gonna try to obtain a legal license then. But anything I know is not professional advice. In no way am I a practicing lawyer. If you have any questions, I would recommend reaching out to a lawyer who is not going to charge you, or even going on Reddit. There's probably some lawyers on there who'd be happy to explain arbitration to you, but use any other resources that you might have. Don't ask me about them. I'm not going to have all the specific answers for you. I apologize, but this is something I do know. So first, the letter itself, you're going to want to send it to Sony Interactive Entertainment LLC. And you're going to want to send it to them specifically because that's the all-encompassing brand. That's going to cover things like Sony's electronics, music, movies, their video games, everything. So send it to them. And the address is going to be 2207 Bridgepoint Parkway, San Mateo, California, zip code 94404. And then you're going to add ATTN, legal department. That's just for their internal mailroom. It just means attention, the legal department. And I see it's online, but you can also ask, put the waiver. I believe that's just more specific for them. But that essentially just tells them where to bring it in the building. Then you're also going to obviously include your address and everything on the top of the letter. I don't believe that this is a toll-free thing. You're probably going to have to pay for a stamp, but I don't send enough letters to know that for sure. And then the inside. Also, this is the most recent address I've seen on any of their websites. If it has changed since then, I do not know. So before you send a letter, I would recommend that you look it up. Also, all this information can be found in Sony's licensing agreement on their website. I believe this is section 9. So if you have any questions, look there. You'll find a lot of the same information. If you can't read my handwriting, which I understand, please go there. And then what you're going to have on the inside is 4 things. First is your name, and that's going to be your government name. So if you go by Nate, but your full name is Nathaniel, you're going to want to put in Nathaniel. Your address, that's going to be your primary address, where you're most often found. So if you're like me, you're a college student, I'm not going to put my apartment number here because I don't consider myself as a resident here. I just live here while I'm at school. So I'm going to put my home address in my home state. If you're a traveling businessman or something like that, enter where your home is, where you're going to file your taxes. And the third thing is going to be your PSIN ID. And it also adds this part, if you have one. If you are not using a PSN account for some reason, or if you're using someone else's account, you're going to want to just say you don't have a PSN ID. And then number 4 is a clear statement that you do not wish to resolve disputes with any Sony entity through arbitration. You can leave it like that. Just say that in parentheses, I do not wish to resolve any disputes with any Sony entity through arbitration. I would recommend not telling them why you want to opt out right away, because that can open the door to negotiation with their lawyers. And you're not a lawyer. If you were a lawyer, you'd probably know this stuff. So I'm assuming you're not a lawyer. You're probably not prepared to negotiate with their lawyers. So I would recommend keeping it vague just so that they don't try to start anything with you. They can ask for more information. As far as I know, you do not have to give them any extra information that they ask for. So that's how to sign the letter, how to send it to them. Oh, also, mailbox doctrine under common law states that once a letter is dropped into the mailbox as an offeree, your letter is valid. So under their clause, you have 30 days to send in the letter. If it's dropped in the mailbox on the 29th, and it has to be like a USPS mailbox, it could be your mailbox outside with the red flag thing on it. It could be the 29th day, but because it's before that 30-day period is up, it is valid. It could get to Sony on the 26th day or the 36th day, but it is still valid. And also, I keep referencing letter. It has to be a letter. It cannot be a electronic email. It can't be a phone call, text message, or anything like that. They specifically say a written letter. And also, try to write it legibly. If they say, oh, we didn't know what the letter was about, we thought it was fan mail or something, the judge would probably agree with them. If your handwriting's bad enough, that's too hard to figure out what it is. But yeah, so that's the letter. Now for what arbitration is. So when you go to court, you're most likely imagining a room with a judge, lawyers, you, and the defendant. That's going to be, in this case, would be Sony, and also a lot of cases a jury. This means that you would go to court if something were to come up, and you would probably have a bench trial. There would be no jury. That can be very time consuming. That's why most people don't bother suing giant companies, and they just settle more often than not. Arbitration is very quick, on the other hand. It can be a day, it could be a few hours, but bottom line is it's very quick. But where the difference is, under arbitration, there's what you call an arbitrator. They could be a retired judge, they could be a retired lawyer. It's just someone with a background in law. There is never going to be a jury. You can have witnesses to it, but you're not going to have a jury. And even more alarmingly with arbitration is that the defendant, again in this case Sony, they can talk with the arbitrator without you knowing. They can email them, they could call them, they could meet them in a separate room, and they can talk about the case without you being present. They could do things like explain like a certain definition. Like, for example, for the celebrate stuff, they could say, Sony could say to the arbitrator, hey, this is what we consider censorship. Can you, in this arbitration case, not consider censorship in any other way? And the arbitrator can agree, because the arbitrator is a private entity. They are not a judge, they are not a lawyer, they are an arbitrator. And any decision that they come up to is essentially another contract where you are signing away your right to pursue the case further. After they say that the case is closed and you sign the paper, there is no alley to appeal. You actually signed away your right to appeal under arbitration. So even if you find out later on that there was new evidence, you can't appeal it. That's why you would rather want to do it in a court case. Also, what arbitration does is that any resolution that's found only applies to you. So say for Celebrate that under arbitration they find that the game was falsely advertised. That's great for you. No one else gets the benefit of you winning your case, only you do. And vice versa, if someone else wins their case, you don't get the benefit. So it would be a case-by-case thing, and it would just be a mess trying to also pay out on a certain thing. So as a consumer, it is not in your best interest to ever go through arbitration. It can be tricky. It can be one-sided. Oh yeah, specifically one-sided because, again, private entity. The company could have a working relationship with the arbitrator. They could use that arbitrator exclusively. So that arbitrator's going to be more inclined to side with the company who goes to them like every year, every day, or whatever the case can be. They're not going to be on your side because you're not paying their bills most of the time. It's going to be the company. So the arbitrator can be biased, whereas a judge is not supposed to be biased. Sometimes you might actually have a better case with a judge who has dealt with the company before because they might not like the company. But yeah, so that is arbitration. Again, these are the 4 things for the letter. If you have any other questions, please ask a qualified lawyer. I'm not a lawyer. And have a great day. And please remember to always know that you as a consumer have rights, and you should not let companies abuse those rights.